So what's going on, at the state level and at the local level? Uh, well, let's talk generally about the status, right, of marijuana laws across the country. And we're going to talk about state statutes. We'll reference the district and the District of Columbia, and we'll reference territories. But basically, marijuana is legal in half the country. 24 states and the district. Recreational marijuana is legal for folks 21 or older. We obviously have a larger number of states where medicinal marijuana, medical marijuana use is legal. So 37 states, right? So we've got the recreational place plus 13 additional states where medical marijuana only is legal. I'm sitting here in the Commonwealth of Pennsylvania. Don't call us a state. We're a Commonwealth where Pennsylvania is a medical only state. No recreational marijuana use in Pennsylvania unless you live in the city of Philadelphia, because you're not going to get in trouble for it. And that's the next slide. Marijuana has essentially been decriminalized, right? Even in areas where you're medical only, or even in some areas where it's not legal at all, we have effective decriminalization of marijuana. So the state laws have changed, right, to match public opinions and to match public action. And again, whether this is a good thing or not, people clearly want, and not just people, big business, because there's money there, want the legalization of marijuana, and states are slowly but surely giving it to them. About half the country lives someplace where recreational marijuana is legal, right? And about 3/4 of the country lives someplace where there's also a medical marijuana program. And so, we're living in the marijuana environment. The state laws, are going to vary as state laws do, right? And again, full employment for lawyers. We get to figure out, why North Dakota is different from South Dakota, right? Gives us something to do. But we can generalize a little bit about the different state statutes that are out there. And a typical state law, right? And your mileage may vary, and consult with your local counsel. And we have a bunch of lawyers on the webinar today, which is great, and a lot of management and then union representatives. So it's a very typical LRIS mix of people. But consult with your local experts as always. But generally, state law is going to have some protection for users, right? Recreational, medicinal, against criminal prosecution or other forms of discrimination, right? And so what about workplace discrimination? Yeah, that's going to be a typical protection. That's why we're talking about it. There'll also generally be exceptions, for categories of persons who are not protected, and you might see a specific law enforcement officer exemption, for example, or a heavy equipment operator. Sometimes they're articulated as safety sensitive personnel. It's going to vary. Whether something is safety sensitive or not is going to depend on the facts of a given case. Pennsylvania has a safety sensitive exception that has not been applied to police officers or firefighters. So you might think that those are safety sensitive positions, but they're not excluded from the medical marijuana law in Pennsylvania, meaning that those women and men who work in those professions are eligible for, assuming they meet the other requirements, for a medical card. And what does that mean for them at work? Right. And that Pennsylvania is not unusual in that regard. What do we generally also see with respect to these things? There'll be prohibitions against drug testing, right? Cannabis screening in certain circumstances, and so pre-hiring is the biggie that you see, but then also potentially, on the job. And this may seem counterintuitive, but gosh, every one of the statutes that I reviewed, and I reviewed a lot of them, make sure to have a specific statement in there saying, employers are free to maintain, they can still maintain those drug-free workplace policies. Notwithstanding everything we just said in the previous 10 pages up to that statement. And so there's a little bit of dissonance there, and employers are having a tough time figuring out, how to proceed, which is why we're talking about, these things. And so, and I love to pick on employers, but employers are really in a tough spot here. And the conflict that we see is, we've got protections, for employees in connection with recreational medicinal marijuana use. And then we've got protections for employers to promulgate their drug-free workplace policies, which are usually manifested, right, through some form of drug testing, ranging from reasonable suspicion to post-accident testing to random testing. And how do we reconcile these competing standards is really what we're dealing with. And, the good thing, I guess, I don't know whether it's a good thing or a bad thing. I was going to say the good thing is that employers, who are participating on this call aren't on your own, right? Because we're talking to an audience, or I'm talking to an audience of collectively bargained, for the most part, workplaces, and even where we in states where we don't have collective bargaining, there is some form of labor management cooperation. With participants that we have here. And so employers aren't entirely on their own. They're going to talk with their unions about how do we deal with these things. They might be legally required to bargain over those questions. And so I don't know whether that's a good thing or a bad thing for employers, but I would say it's a good thing. You're not alone. You get to talk to the employees about how they feel about some of these difficult questions.